The Chicago Bar Association was created back in 1874 as just a general resource to help attorneys network with each other and be successful in their practices. The CBA chose to set up the insurance subsidiary because a lot of the members were asking questions about what types of insurance they should tap into. Who's the best resource for legal malpractice insurance, life insurance, health insurance, et cetera, et cetera. And rather than sending those elsewhere, we figured we'd be a better resource if we just kept it all in-house and they had a familiar face to work with on a regular basis. And we think that it's very important to get the word out and let our members know that we're around to help as a resource. On top of that, we can work with any law firm or any attorney in the United States. When a law firm comes to us for a second opinion on their legal malpractice insurance policy, we're usually able to find them a lower price for the same coverage or better coverage, or in some instances, actually both. We can find a lower price for better coverage, which is obviously the end goal. Insurance is something that not a lot of people know the ins and outs of it, and maybe a smaller firm or a solo attorney needs that consultant to really keep them in line or to provide information to take it off of their plate. They have enough going on dealing with clients, collecting bills, doing everything that makes them successful in their profession. What I'm here to do is to be a resource and really just provide assistance in something that they are not inherently an expert in.
Welcome to You and the Law, a program produced by the Chicago Bar Association that explores legal issues and policy matters of public concern. We have a very special program today. We have three guests, Sandra Crawford, Patrick King, and Jim Alrutz, and they will be sharing some of their background. There's a lot there. If you could pick a few things that are relevant to our topic, there's so much to talk about, and you've all done so many things. Our topic today is the lawyer as peacemaker, and we're going to be exploring the spirit of what it means to be a lawyer in terms of resolving conflict, and frankly, the social utility, which is not an intellectual process as much as is a very basic principle that's rooted in having societies that work well without chaos. And I think it is kind of, in some sense, that simple. So with that, I'm going to ask you each to introduce yourselves and provide a little bit of background that puts this in context and shows what you bring to the table. And perhaps we'll start with Sandra Crawford, who, among other things, has been the Illinois Bar Foundation president. Of course, the IBF, the principles we're talking about today are embedded deeply in that institution. So go ahead.
Well, thank you, Mike. I'm very grateful to you and the CBA for this opportunity to dialogue with Patrick and Jim from CCR about something that I've been very passionate about most of my career, which is lawyers as peacemakers and healers. I don't think that is the view that people have of lawyers when you say lawyers. That's not the initial reaction people have to lawyers as peacemakers. But I've been practicing now since 1990, and I became a mediator, trained with CCR, where Jim is now, in 1993. So very early in my career, I also included, litigation and mediation, and started to explore a lot of the other ADR forums. And that's probably a whole show in of itself. But all just for general knowledge, ADR, alternative dispute resolution, which is anything alternative to litigation. And that includes mediation, collaborative practice, arbitration, and then the various forms of that. I was very lucky in 2002 to be among the first class of Illinois lawyers and other professionals to be trained in the collaborative model. And the collaborative model is non-court process, non-litigation, out of court, helping people sit around a table with a team of professionals, including lawyers, mental health, and financial professionals in the family law realm, to resolve conflict and not have to go to court and, the backlog of courts and leaving judges to make decisions about families. And I will tell you, I'm part of the International Academy of Collaborative Professionals, which was nominated for a Nobel Peace Prize last year, 2023. Yeah, it was one of 93 organizations nominated, but the fact that it was nominated and that a lawyer, a frustrated family lawyer, set out in 1990 to create a model that would change how families, that they weren't fighting, that they were cooperating. And it was nominated for its efforts in transforming how conflict is addressed in family law systems around the world. And so that was very much part of my career. I could go into the law, how in Illinois, we now do have statutes that support mediation. The Uniform Mediation Act was adopted in part in Illinois, and I can give you, chapter and verse on that. And we were very lucky also to pass the Collaborative Process Act, which is, again, parts of the Uniform Collaborative Act. So there's lots to be said about that. But I'm really grateful for the opportunity to talk about this concept of lawyer as peacemaker, as opposed to lawyer as gladiator, fight to the death for your clients. Doesn't mean we don't advocate for our clients' best interest and for their highest and best value, but it is a little bit of a different approach. And I think it's an approach that still the profession needs to embrace a lot closer than it has. But thank you.
Absolutely. I appreciate that. And I'm going to go to Jim in a moment, but I just wanted to point out, certainly, like, part of the sort of perennial struggle from my perspective, my own take as a lawyer, is constantly reconciling and managing that commitment to the judiciary, the rule of law, civility, and reconciling that with the fact that there is real heavy-duty conflict. And that's where we do our best work, I think. Jim, I'd like to go to you next, because we'll go to Patrick to finish up, because it was really his recent article that got the ball rolling. Although Sandra's written one very, on similar topics too, and Jim, you've done a lot of that work too. Jim, tell us about yourself a little bit.
Sure. So I am one of the programs directors at the Center for Conflict Resolution, which is a community mediation organization that provides free services throughout Cook County and the Chicagoland area. And the program that I primarily work on is part of a broader project called Cook County Legal Aid for Housing and Debt, or CLAD. So that's a program that helps divert eviction, consumer debt, and tax deed cases to get access to legal aid from a number of different organizations, as well as CCR's mediation services. So I spend a lot of time in court calls helping self-represented landlords, tenants, debtors get access to mediation and to legal aid, because within this rule of law, overarching idea, there's a lot of access to justice work that can be done to make sure that in situations like eviction cases or in small claims cases, that parties are able to navigate a system. Because if the system is impenetrable and they don't feel like they can handle what should be a relatively small sort of dispute, then that foments a sense of distrust in the system, or a belief that they can't use the system. It won't be helpful to them to get their situation resolved. And so whether they're getting things resolved because lawyers are more available to them and that gives them an opportunity to have assistance with negotiating, or because they're going to mediation services and they're working things out themselves, those programs give people the ability to get situations resolved more quickly than they would without access to those resources. Another hat that I wear is I'm adjunct faculty at Loyola Chicago, which is where I met you, Michael, on a class called Professional Identity Formation. So this is coursework that Loyola is really trailblazing on, because now the ABA is increasingly requiring law schools to have curriculum like this that discusses things like intersectional identity and implicit bias within the legal profession. And we were really ahead of the curve. And so I teach the class now, but when I was a student at Loyola, Michael was my professor, and I'm not going to say when that was in order to preserve both of our dignity.
Yeah, I appreciate it. Thank you very much. I appreciate that. Now I'm going to turn to Patrick, who in the most recent issue, the March issue of the Illinois Bar Journal wrote this really wonderful article that I'll kind of show you, and it's got a great image with it, and the content is even better. So Patrick, thank you very much. Share a little bit about your background and perhaps what motivated you to write this wonderful article.
Yeah, thank you, Michael. Thank you, Sandra and Jim as well, to the Chicago Bar Association. So I'm a practicing lawyer in Madison County, Illinois, which is 4 or 5 hours south of Chicago. Licensed in Illinois and Missouri. I'm with a law firm here. It's a small firm. We're comprehensive, so we practice a lot of different areas, serve a lot of different clients. My area is really, in particular, concentrate in personal injury on the plaintiff's side, wrongful death, municipal law, police and fire boards. I serve as a guardian ad litem for disabled adults as well as minors involved in accidents, and also mediation, which is something that I have found there's a need and there's a desire for it. And I do believe it's not only for the present, but also for the future. So that's a little bit about my background. I'll kind of pause there, Michael, and give you a chance to ask some follow-up questions and to lead us in conversation.
For sure, I appreciate it, and you know, time is short, so we might have to do kind of big picture things, and that your intros are very important. What you bring here and your history of working in this manner is really important. So it's worth spending time on. I want to read to you a very well-known quote by the famed American cultural anthropologist Margaret Mead, and I want to get sort of a quick reaction, not quick rushed, but just kind of quick take. The quote is, "Our first and most pressing problem is how to do away with warfare as a method of solving conflicts between national groups within a society who have different views about how the society is to run." Sandra, I see you're already engaged. Tell me what's on your mind. Oh, you're muted. We cannot hear you. There you go.
Yeah, I love Margaret Mead. I'll trade you quote for quote. When I present on this, and when I talk, and I've taught mediation at the college level as well as at the post doc level at Northwestern. I teach the 40-hour divorce mediation course over there, and I use the Abe Lincoln because Abe said, discourage litigation when you can. Make sure that your neighbors know that, litigation can be a waste, and now I'm butchering the quote, a waste of time and costs. So I think Illinois has a very unique history of this idea of we don't have to go to warfare, and litigation is warfare. It's a war model, right? And if that's our primary, when people think of how they resolve conflict, that they have to go into a war type model, right? You get to no wonder we don't have these ideas of conflict can be resolved at a different level. Yeah. That we're always we have to fight for our rights, as
war on drugs, war on everything, war on poverty. It's not, war is creating these things. That attitude is creating a lot of this stuff.
There is some wonderful work that has come out of the International Academy of Collaborative Professionals, and one person in particular, a woman by the name of Sharon Ellison, wrote a book called Taking the War Out of Our Words. And it's basically how we communicate with each other day to day.
Right.
Our communication is based on this war model. And if we just put down the armor and sit and have conversation, and that's what mediation, and Jim will tell you this, that's what they do. That's what I learned. I trained at CCR. Just sitting in a room and changing the language and listening and learning how to reframe and give feedback and truly hear people. I think the solutions that come out of mediation and collaboration, what I say to people is they're much more sustainable because people have really had a good heart-to-heart chat about what's important to them. And then from that framework, set up the process for going forward. As opposed, and I mean, I'm an officer of the law, I'm a licensed attorney. I litigated for the better part of 25 years. I still take on litigation year to year when I say, I'd rather not, but there's some cases that belong in court. There's
Right.
some cases that people need adjudication. I just
Right.
wrote an article for the ADR newsletter at ISBA about adjudication versus ADR,
Mhm.
right? You know, they're not mutually exclusive. I mean, and at least in family law now, there's cases that can get mandated to mediation. But I think it all comes back to, Mike, very simple things like just how we speak to one another, right? How we talk to one another. And, you know, it escalates real quick. If all people think, you know, it's the old adage, if all you have is a hammer, everything looks like a nail. If
Right.
all we think about when we think about the law is, I've got to protect my rights and the judge is going to do that for me, I think we do a disservice, because the courts are you know, backlogged, as you said, because of COVID. There's, you know, now there's, you know, concerns about people having access to the courthouse, and access to justice is a real problem. And one of the problems you and I work on the board of the Illinois Bar Foundation, which is the charitable wing of the State Bar Association, where we're funding legal agencies who are dealing with people who can't afford to go to court. So the mechanisms were provided for resolving conflict, which is, most people think, go to the court immediately. Those mechanisms are under stress, if nothing else. And if we could
Absolutely.
have a different conversation, a politer, kinder conversation, a lot of the conflict, going back to kind of the Margaret Mead, you know, let's not start with the war model. Let's start with a gentler, kinder, you know, conflict will arise. We are humans. We will not always see things eye to eye. But if we can set up mechanisms like CCR is just a wonderful, and I think it's a model for nationwide for centers that can be set up. And I know there's a lot of push, at least here in the, you know, the metropolitan area, to try and, you know, copy those those mechanisms so that there's places for people to go and not just directly to court, where some people can't even afford lawyers.
Right. So I want to make a quick comment on that. There's a lot there, but a couple things I just want to kind of explore a little bit, and then I want to go to Jim and Patrick. You know, I wrote an article probably during, I don't know, it was in the last 4 or 5 years. It was, well, no, it was longer than that. It was after the election cycle. Well, anyway, it was about a vitriolic election cycle and civility in the law practice. And the very basic principle, and I think I probably started the article with it, is just that, you know, without conflict, our judiciary is irrelevant. We don't need it. We need it as a matter of fact because we have conflicts that need to be resolved through reason, rationality, and principles that we can all see, universal principles, which are embedded in the Constitution and the International Declaration of Human Rights and all our post-World War II human rights infrastructure. And some of this is even going on now, right? And without getting into great detail, we have right now, you know, a serious situation, quite serious, you know, in the International Court of Justice, and Israel is defending itself against genocide charges brought by South Africa. Now, if we reflect on the principles that led to that infrastructure, they're identical to the principles that are embedded in our Constitution, and they're identical to a lot of very basic democratic constitutional principles that are frankly rooted in ideas of human nature, and we need to kind of think about those things probably a lot. Without civility, our judiciary is impossible. So without conflict, it's irrelevant. Without civility, you know, it's impossible. So that's quite a tension to navigate, and it really is sort of something to manage in a perennial sense rather than a problem to solve once. You know, as far as I see it, Jim, and time is moving awfully fast. Jim, go ahead.
Yeah, I'll try to be quick, but I'm going to build off a couple of things that Sandra had said. To the point you were talking about with kind of the sturdiness of an agreement, I think one of the things that's nice about mediation is that it has the capacity to create a more complete resolution than what the courts might be able to offer. Sometimes in training for mediation, we talk about creative solutions, but just the fact that parties who are sitting down to an agreement and what is essentially a mediation agreement is a form of contract, gives them a lot more flexibility than a judge who, especially in a smaller claims case, or even a bigger case, might only hear the case for a brief period of time and they issue a decision that isn't going to be comprehensive about all the issues that parties have. So I do a lot of landlord-tenant things, and so you might have a case where a tenant is agreeing to stay in a property and make additional payments to catch up on rent, but the landlord is agreeing to make repairs that the tenant has requested or something else in a way that a judge is not going to offer a resolution like that. And sometimes in crafting these agreements, as mediators, something I do when I'm mediating and when I'm training new mediators is talking about asking questions to make sure that the agreement is comprehensive. And CCR's model is outcome neutral. On a personal level, I might really want the parties to come to an agreement together, but in the capacity as a mediator, whether or not they reach an agreement is not something that I invest myself in. I don't try to steer them towards a particular solution. And sometimes I ask questions that the parties might say, well, wait a minute, why are you asking this? You're blowing up my agreement. And I say, look, I don't want you to have an agreement that isn't based on a firm foundation. If you have an agreement and then a month later, y'all are back in court because one of you has breached an agreement because you agreed to do something that you just didn't have the capacity to do, I don't actually think that helps you. I want to make sure that this is a well thought out agreement. And if we're going to sign something today, this is something that everybody feels like they can hold up their end of the deal, that this is a complete issue for them so that you don't need to go back and seek more relief from the judicial system. And I'm sure, Patrick, based on the different areas that you practice in, you've probably got some similar stories about just the need to get that kind of complete resolution in a way that might not be able to be offered through traditional litigation.
Yeah, thank you, Jim. You know, when we're thinking about lawyers Peacemaker, mediation is I don't just want to say it's a tool. I think it can be a primary tool to resolve disputes. And when I wrote the article Lawyers Peacemaker, I had kind of looked at it from advisor, evaluator, advocate, and negotiator. And there are times when a case is not simply ripe for mediation. I think oftentimes cases should go to mediation earlier in the process than later because of cost, stress, hardship on the parties. But as we've talked, the rule of law is important. And so it is incumbent upon the lawyer at all stages, advisor, evaluator, advocate, negotiator, to be a human person in the process. And I think as we're talking about basic human nature, basic principles, there's something that maybe our culture and society and maybe the world at large has idealized or glamorized battle and war. And as lawyers, we know all the television shows, we know the movies, we know the great characters of literature, these great advocates, these characters who have rhetorical skills and can advocate. And some of that, there's a time and a place for that. But there's also a time and a place to step back and serve as a peacemaker. But even in a trial, I do think if a lawyer is civil, professional, honest, ethical, and realizes that the other side, they're human beings too. There's dignity to human beings. All human beings have dignity. Then I think even a stressful trial can still be very human, can be still a very human experience, not robotic, not a zero-sum game. And so writing the article was inspired in part by, as you mentioned, Abraham Lincoln, human nature. And there's a lot of human principles that we can apply that perhaps before law school we had, and maybe after law school we somewhat lost in translation. So I do think part of our education should be learning sometimes how to be human again and how to treat people with mutual respect and dignity. So my article had different reasons for writing it, but I'll pause there and let Michael jump in.
No, I love that. I want to do two things. One is, a little less clinical, because when we're talking about this, we really move into philosophical and perhaps even what you might call, depending on how you feel about things, spiritual issues. There's an issue of, you can just talk about it. You don't have to talk about it in terms of religion, but just the spirit of a lawyer. And you've talked about that. And the thing that I wanted to do real quick, so I want to show you, because there's a lot of Abraham Lincoln talk. When I wrote that article, a few things were going on, but I got married during the pandemic. There was great unrest, and this is my son, Abraham. My wife happens to be Jewish. I'm Palestinian. There's other stuff too, but, there is a lot going on there that I think is quite important. It's about being human and very basic, and not about these intellectual processes so much, but the intellectual processes hopefully aid us and developing systems that encourage, and Dutch to flourish and provide conditions for that. Now we've got only, I think, 5 minutes left. So I want to conclude real soon, but I'm going to read a quote that's pretty heavy, and I want to get a quick take because I think that worked before, but it's going to be ultra quick. Charles Hamilton Houston, the wonderful human rights hero, known as the man who killed Jim Crow. Now we use the word "killed" there. That's in an ABA article. But that's a reference to dismantling a racist legal framework. So his quote: "A lawyer is either a social engineer or a parasite on society." Now, here's what I think about that in short. I think, in a sense, it is somewhat hyperbolic and polarizing, and I think it's false binary in some sense. Okay, because I just think it's false binary. However, I think there's very, very serious truth to it as well. And share some super quick thoughts, and then we will conclude.
Well, I think that goes to the root of the problem about how we're viewed as a profession. I think that is an inside the profession problem that we're still working to address, right? We have to. There's a wonderful ABA book by a woman by the name of J. Kim Wright. It is Lawyer as Peacemaker. That's the name of the book. But it still seems like a hard sell within our profession that somehow we are not, fully supporting our clients if we take this idea of peacemaker, that somehow that is that we will be taken advantage of, or that we will be less than. And I think that's a problem that the profession still has to work on. And from that work, it's like lawyers can teach other lawyers, about ways of finding satisfaction, because the win is great. If you win in litigation, there's a real high to that we cannot step away from. Yeah. But that, lawyers we can focus on like comprehensive solution, focus, service focused for the clients. Winning is not, everything. The best outcomes, as Jim was saying, are outcomes that a judge can't. I mean, judges are bound by the law. A judge cannot give the level of creativity because they're bound. They have certain discretion under the law. But parties sitting together around a table, sharing sometimes. I mean, we bring food to our meetings, breaking bread together.
Much better opportunity for resolution, and we're right at the end here. There's that Sandra, and I hate to cut you off because that's why we need to probably do more programs on this. And I really thank everybody, and I'll keep it real short here and just say that, there are many lawyers out there doing incredible things, and I really am so happy that you, and so many like you. But you're certainly leaders, without question, a variety of ways, participated in this, and what you're doing is wonderful. You are doing, in my opinion, absolutely what lawyers should be doing, and encouraging us to cultivate and think about these things. Because I do think we get stronger when we think bigger like that. It's not a weakness. It's really not. I don't believe it is. Resolution is what we are really supposed to be, after. So thank you all very much for attending, and thank you, the audience, for watching this episode of You and the Law.